Good morning and welcome to Gowling WLG's webinar on Brexit. This is an audio webinar, and I think one of the disadvantages you've got of that is those of you who are listening in, and there are quite a few of you, I think we're billed to have some 300 joining this webinar, is that you're missing the collective looks of shock and surprise on the assembled panel who are going to share their views on what last night means for all of us. Obviously, the main purpose of this webinar is to encourage audience participation. So those of you who are listening in should have in front of you a webinar player which will have volume adjustment and full screen options on the bottom right-hand side of the player. And the thing I would really encourage you to look at is the Ask a Question tab, because that's really what we want to generate is a raft of interesting questions that our panel can reflect on and perhaps help answer. Questions, when they come in, will be allocated with your name. So if you want to ask a question anonymously, I think the thing to do is at the beginning of your question, just put in the word anonymous at the start, and then we can make sure that that is respected when the question is asked. We hope to get through most of the questions, but there may well be one or two that we miss on the way through. But we'll be picking those up and follow up with you after the webinar if that's okay with you. But probably just to set the scene while questions are coming in, it's probably just best to remind ourselves, well, what does happen next? What is the framework? Two things: what is the mechanism by which we exit? But then, secondly, perhaps what are the options after we exit? What other kinds of relationships and treaties can we make? I'm going to start with Kieran Laird from our public regulatory team, who's been very much involved in the mechanics of exit. Kieran.
Thanks, Michael. Good morning, everyone. The first thing to remember is that legally nothing has actually changed this morning. We've woken up to a leave result, but all of the EU law that we had yesterday still remains in place. Our courts will still have to apply the treaties, and the Court of Justice of the EU will still have to apply those treaties in anything brought before it also. And that's going to remain the position for a few years to come, in fact. So although there may be political and economic short-term shocks, there will not be much change legally over the next year or two. And that's essentially because of the way the withdrawal process works. The first thing that the government would do would be to notify the European Council of its intention to withdraw from the European Union. That's done under Article 50 of the Treaty on European Union. Vote Leave over the last few weeks and months has floated the suggestion that there might be alternative ways to leave, for example, in the same way that Greenland did so. However, to be honest, politically and for various legal reasons, they simply aren't credible. So I think we're going to go through the Article 50 process. Now, we don't have to immediately give notification to leave, and the Prime Minister, in his resignation speech this morning, said that it would be for the new Prime Minister following his or her election in October to do so. So we're not even going to get started on this process for a couple of months to come. Once we do give notification to leave, we will then enter into a period of intense negotiations with the European Council, probably fronted by the European Commission actually. What we will be negotiating is a thing called the Withdrawal Agreement. And the Withdrawal Agreement will cover the terms of our exit from the EU and our future relationship with it. Now, there is a timeline in which we're going to have to do that. Under Article 50, if we don't negotiate a withdrawal agreement and have it coming into force within 2 years, we will essentially leave the European Union without any alternative mechanism in place. And my colleague Bernadine's going to come on in a few minutes to talk about what the options are. But that would essentially mean that we reverted to the World Trade Organization rules. So that 2-year period is extendable by agreement with all of the other European countries. And and to be honest, it's probable that we will actually extend that period. Vote Leave have said that it'll take about 4 years to negotiate an alternative withdrawal agreement. But to be honest, an awful lot of other academic and governmental projections put it between somewhere like 4 to 9 years. So we're not going anywhere fast, I have to say. And we could see the law from the European Union remaining in place at least for another 4 years.
Thank you, Kieran. We've got some questions coming in, but then just quickly before we start picking those up, Bernadine, who spends a lot of time in our Brussels office, what are the potential options?
I think it's useful to look at these different options, because not only will it govern our relationship with the EU, it would also govern our relationship with what we refer to as the acquis communautaire. In other words, the existing EU rules that we have in our legislation. So there are essentially 5 models which are possible, which have been canvassed. From one extreme is to being in the full fold of the EEA agreement, such as Norway and Iceland. That is likely to be unpalatable, because essentially you are agreeing that the UK will be agreeing to be part of the EU trading bloc, but staying outside its formal structures for adoption of legislation. And essentially you're agreeing to the four freedoms, which includes the freedom of workers, which may be currently unpalatable, and also it requires a sizable contribution to the EU budget. The other extreme is to be within the WTO, where you will simply be another country vis-à-vis the EU, such as India or Brazil, which is unlikely to happen. There's a school of thought also at the moment going through, because the more recent rounds in the WTO with the EU and the UK have been agreed. The UK has agreed those rounds under the auspices of being an EU member, and its quality as a state is changing. So clearly whether the UK will go back to square one within the WTO and have to engage in a series of rounds of agreements, not only with the EU but also with its other trade partners as well. So those are the 2 extremes. In between there we have essentially the Swiss model, which I think is probably the most likely. The Swiss did originally want to be in the EEA, negotiated extremely hard, at the last minute pulled out. So what we have with the Swiss is a bundle of bilateral treaties which encompass some 100 different agreements, which primarily allow us to grant the Swiss access to the single market, and they deal with such issues as free movement of capital, financial services, environmental cooperation, and importantly also freedom of persons. So that's very much a possibility, sort of an a la carte type agreements on a bilateral basis. The downside of that, you have static agreements, bilateral agreements, which are essentially frozen in time, and you don't have a proper dispute mechanism. The other option is a UK-EU free trade option, where essentially you just simply get into the access to free trade, including for financial services, very fluid, not quite sure as to what that would encompass, but would be unlikely to encompass such things as the free movement of goods. And then last but no means least is the Turkish option, which is a good old-fashioned customs union, which wouldn't extend to professional services, but be quite cheap in the sense that you don't have to contribute to the EU budget. Query what it would look like, because there's a huge disparity in bargaining power between the EU and the UK, and we would have tariffs then put onto UK goods, ranging at the moment. The common external tariff at the moment is 10% for cars, 11% for clothing, 15% for food, for example.
Okay, there's some people with hearing issues. Just reminding speakers if they can speak up a little, please. We've got a couple of specific questions coming in slightly tied to that point. Obviously, there's quite a bit of legislation on the stocks at the moment. Peter Hall, who's our IT person working in data protection, Martin Chitty in relation to employment. There's some existing stuff floating around. What's going to happen to that? The data protection regulations is a very good example.
Okay, so my best prediction on data protection is that we will end up with something like the new set of regulations in place anyway, and the reason I say that is if you look at the EEA countries, for example, most of those have laws in line with EU data protection laws, and there are good reasons for that, because, for example, on things like data transfers, it makes a lot of sense to have laws aligned to allow for free movement of data, and therefore I think my best prediction on data protection would be that we will end up with something like the GDPR in place. There may be some room for amending or lightening some of the burden of that regulation in our laws, but I think we'll end up with something broadly aligned to the new regulations in place. So my view would be for businesses on that particular area, I would keep looking at introducing what you need to comply with that, both in terms of your internal policies and your contracts over the next 2 years, on the assumption that we will end up with something looking like the GDPR anyway. And obviously, we will know more about that as time progresses over the next 2 years.
Kieran, I think you had a comment you wanted to add to that.
One of the interesting things that touches on this question is Vote Leave's proposal for a European Union law emergency provisions bill within the lifetime of this current Parliament. And this was part of Vote Leave's withdrawal plan. And what they're essentially saying, and it remains to be seen whether they're actually going to go through with this, is to pass some legislation limiting the effect of European law within the UK while we negotiate the withdrawal agreement. That has certainly been proposed. Whether or not it's actually going to happen or not is another thing, because there are massive legal and certainly political implications of that. It will, for example, place our devolved administrations in quite a difficult position. It'll also place our courts in quite a difficult position. But from a purely practical point of view, what we would be doing with a bill of that nature is to effectively breach our obligations in international law to the EU during the course of negotiations for our ongoing relationship with it, and that may not be the best idea practically. So we hopefully won't see that sort of domestic legislation in the interim disapplying these EU law provisions.
Thank you very much. Martin, we've got a question here about references to EU law. There's tons of EU in contracts, the application of EU law in contracts. There's tons of employment law knocking around, and particularly around the acquired rights directives. I mean, what would a reference to including EU law mean now, do you think, in your context?
Well, I think it's an interesting question, and one that depends on the specific terms in the contract.
Yeah.
If you've got a reference to the acquired rights directive, we're still subject to the acquired rights directive, in as much as it's directly enforceable in a private law contract. If you've made reference to the transfer of undertaking regulations, which is the UK implementation of the acquired rights directive, they're in place, and they will be in place until they're repealed, whether we're in the EU or not. And there's quite a lot in the transfer regulations which is not actually derived from the directive itself. It's something which is what can be referred to as embellishment or gold plating, depending on how you look at it. So service provision change provisions are not from the acquired rights directive. They're an entirely English law or UK law concept. So in the short term, nothing's going to change. And even if and when all of this is resolved, is the service sector going to find that actually the service provision change provisions facilitate the operation of the market, because they avoid massive redundancy costs on exit. So commercially, it may be that the parties migrate from a position where they're making reference to the transfer regs and simply have an agreement under contract that this is how it is going to be approached. The question has come in about posted workers and whether an organisation sending people across Europe to work for short periods is suddenly going to find its business model affected. And I would say in the short term, legally, it should make no difference at all, unless and until the law actually changes. Practically, it may be that local market practice becomes more resistant to posted workers being sent in on the basis that it's less likely that anything would be resolved other than at a very local law, local court level, if somebody challenges the proposition. So it may be that because this referendum has come down on this side of the vote, that actually doing business in Europe day to day on a practical level, rather than a sort of macro political level, becomes more difficult.
One of the areas where I think we've got used to EU law applying is in relation to procurement, Sarah. I just wonder what you think's going to happen in relation to application of procurement rules.
I mean, it's a bit similar to the position with the Acquired Rights Directive, really, because most of the procurement regime has been implemented into UK law through statutory instrument, through regulations. And actually, if you look back over the last sort of 20, 25 years through the history of procurement, actually the UK had compulsory competitive tendering, for example, so a requirement to go out and compete contracts before we were actually required to do so as part of the free movement of goods and services principles. So, you know, I think my analysis at the moment is clearly there won't be anything changing soon because we've got those rules into UK law. A bit like the TUPE provisions, actually the UK has gone further than it's required to do through the EU directives. We've got the Lord Young reforms which were implemented in the regulations last year. And actually, as Bernadine said, we really need to wait and see what model the UK is going to adopt in terms of, you know, are we going to have a deal akin to Norway, or is it going to look something more like Switzerland? But as I understand those deals, they often have built into them requirements around free movement of goods and services, and actually the procurement rules are just, you know, one implementation, if you like, of that broader principle. So I'm afraid for all of those who thought that you might be able to take this opportunity next week to issue tenders and, you know, not have to follow the rules, I'm afraid that isn't really going to be the case.
Okay. I just wonder if I can take a sort of straw poll around the various members of our panel here, because we've just had a wonderfully broad question coming in, which is perfect for everyone to answer, which is in relation to your own particular areas. What if you were advising your clients' businesses, what practical steps they could do to work out how they're going to prepare for the UK exiting the EU? What would they be? I'll probably start, if I may, with David Lowe, who's our commercial contracts expert.
Thanks, Michael. I mean, the first thing on the commercial contracts that people should be doing today and next week is considering the immediate aftermath of this vote. Massive changes on the currency markets, for example. What does that mean for your contracts? Imports will now be more expensive, exports will be cheaper. How do your contracts manage currency exchange risk? And of course, everyone will be looking at current transactions which have not been completed to decide, actually, in this new uncertain world, do we want to complete it? In the short term, possibly, subject to those currency exchanges, but are you going to enter into, say, a 5-year exclusive distribution agreement in Germany right at this moment, when actually you have it's difficult to predict what the environment will be like? I think also then, after that immediate aftermath, the next step must be to consider people's business models. To what extent are people's business models potentially affected by this? Financial services being a good example where European financial services regulation has a big impact, both in burden but also opportunity. And what should people be doing to guard against that? And I'm sure there'll be a lot of commentary in different sectors about that. You know, should you set up a subsidiary in Dublin or not? And then looking further down the track, there will be considering what's in contracts. I'm afraid I think people need to be going through the same thought process they were going through in 2008 and 2009, where we had a recession, where there was considerable uncertainty. You know, what happens if people go insolvent? What happens if people in my supply chain go insolvent? How are my contracts set up to deal with that? There will be the interesting wrinkles for the longer term contracts about what's the impact on European Distribution Agency licensing arrangements, which might refer to exclusivity in the EU or might be crafted to take account of EU antitrust law. And of course, IP protection is also going to be an interesting issue. But of course, looking further ahead, we've also got to think about the opportunity. We hopefully, if we believe the Leave camp, that we're opening ourselves up to a huge range of future opportunity in international trade, and therefore considering what those options are and how to embrace those must be a key requirement for anyone in business.
Okay, Tom Price is one of our litigation experts here. I mean, we've all got comfortable with the idea of enforcing judgments across Europe. What's Brexit going to do for the litigators?
Well, you're mainly concerned with how easy is it going to be to enforce the contract. As far as dispute resolution is concerned, that really breaks down into whether you want to arbitrate or whether you want to use the state courts. The state courts, if you're talking about around Europe, that's where the uncertainty potentially now lies. But I actually think that it isn't going to mark any particular change from what we've had to date. At the moment, we have the EU judgment regulation for easy enforcement around Europe. But even if we were to effectively exit that, I think it is highly likely we would just replace it with the parallel convention that Switzerland has at the moment and other EFTA countries, and that is a very similar regulation. So I think in the medium to long term, actually, probably very little difference. The fallback is that arbitration has not been touched by EU legislation nearly as much. And to be ultra safe, I guess an arbitration clause might be the safest bet. That would be my view at the moment.
Just one issue on litigation before we carry on going around the room on that. But the question's arisen as to the UK being naughty in the period between now and exit, and the likelihood of the Commission taking infringement proceedings against us. I'm guessing, Bernardine, this is very much your area, they can still do that, but do you think there'll be the political, practical will to do this? Does it make sense?
Well, looking at it pragmatically, it takes so long to start the infringement proceedings against a member state will be out of the EU by the time the Commission gets moving on that. But in principle, yes, they can be had up for infringement. But that's going to be a bit of a damp squid, I think, that possibility. By the same token, it also means that in this interim period, the EU is still a fully fledged member of the EU, and it will still sit at the table when they are crafting EU laws and EU norms. Query as to how much you're going to listen to the EU, given that it's now in the waiting room, is another question altogether.
We tend to rely on what I might call UK real estate as being the stable partner in all this sort of Brexit excitement. But I can't imagine that the real estate market is going to get off scot-free with what's going on with Brexit at the moment. It must have supply chain issues and market issues. Richard?
No, I agree with you, Michael. I think the property industry is probably just going to pause and get its head around some of the ramifications of all this. I think putting a positive spin on it, which is the case, certainly this will create buying opportunities for certain of our clients, and a number of our institutional clients are very cash rich at the moment. So if we see a big shift in asset prices, then that's good for the industry in terms of purchase. But undoubtedly, various sectors of the property industry, not least the house builders, will be pausing to consider what's going to happen. One of the things that's concerning me particularly is with the effect on the pound. If the Bank of England decides to raise interest rates to defend the pound, you could imagine an instant hit on the mortgage market, and that, of course, will affect the buyers of the plot significantly. So I think probably we'll see a period of most of the major players pausing, watching the initial turbulence settle, and then making decisions. But in the meantime, what we're trying to do is introduce clauses into various of our deals, giving our clients the ability to pause and reconsider and rescind or maybe condition deals so that we can make a decision as to what we want to do when things have calmed a bit.
Thank you. Sunil, I mean, you're head of our corporate team, and obviously we get heavily involved in a number of cross-border transactions and deals. Any immediate impact for you? Or
I think inevitably, Michael, business hates uncertainty, and we've seen the pound drop to a 30-year low this morning. FTSE having dropped 8%, then picked up. A bit like Richard's comment about real estate, I suspect that a number of our clients who are already in the midst of transactions, particularly cross-border transactions, will pause for thought. I think they will want to see the degree of calm return to the market before they pick up the pace on those transactions. Interesting opportunity, I suspect, for cross-border transactions where it's inward investment into the UK, because just the relative weakness of sterling against other currencies makes the UK an attractive destination, or an even more attractive destination.
I think in the medium term, there will be question marks around the attractiveness of the UK as an entry point to the EU. And I suspect that a lot of investors will be looking at positive messages coming out about how our relationships with our EU member states are going to be renegotiated to ensure that we have more or less the same arrangements as currently prevail. I think the one area of business where I suspect we will see an immediate impact is around financing. I think eyes will be firmly focused on the MPC meeting in July, and where the governor decides to peg interest rates at that meeting.
There's a fantastic question up there for you, Sunil, on insolvency. I'll give you a couple of minutes to think about that one while I move on to Martin. I mean, I was listening to the radio this morning. I've got to the age, as you know, where I'm listening to radio. Thought it'll be Saga Radio next. But we had the unions on there this morning saying that we really must defend workers' rights. European employment law has always been very pro-employee. What's going to happen?
Well, again, we come back to the point that nothing's going to happen today or for some years from that point of view. And it's true to say that there are lots of the more progressive pieces of employment legislation, particularly on the social policy front, which derive completely from EU law. The way we've tended to categorise it is that there are some things which will change, which will stay untouched because they're underlying UK legislation, so unfair dismissal, principles of sex and race discrimination, equal pay, things like that. They've got nothing to do with the EU. There's definitely a category, though, of issues which are on the endangered list. But so much of it depends on the political landscape here, who's in government, and certainly were it a Tory government going forward, which end of the spectrum that government is controlled by. But on that endangered list would be things like large parts of the working time regulations, particularly the 48-hour opt-out, and the 48-hour working week, rest breaks, paid waiting time, and the way in which we calculate holiday pay, which all comes out of those regulations. And people seem to forget that there is no underlying legal entitlement to paid holiday in this country, other than through the working time regulations. The issue is how you calculate it. Other things might be around collective consultation on redundancies. There is nothing in English law other than the Collective Redundancies Directive, which compels the UK to do that. So it could be that the government is minded to repeal all of that. Query, is that politically deliverable? In the same way, the Agency Workers Directive, not massively popular, entirely EU-based, and probably the top of the hit list for many on the Leave side. It's interesting that the Leave side, one of the Leave side's arguments was that, such as the embellishment of employment rights under the EU, that there should be a natural opposition towards it. And that seems to have been supported by many of those you would take as natural Labour supporters, who seem to be voting for a reduction of their own rights. But nothing's going to happen in the short term. There's no need for employers to change anything that they're doing today or tomorrow, and unless and until we see how this pans out. And Kieran's point about the prospective repeal, effectively, of the European Communities Act and all EU-derived legislation, I think is massively, massively unlikely and not deliverable in any way at all.
Kieran, in your neck of the woods, are you going to see, you think, a massive uptick in what I might call regulatory work, and there's going to be a whole raft of new legislation that's going to need absorbing, I would guess?
Yes, I mean, it's an interesting question, just how we're going to disentangle our domestic legislative landscape from that of the EU. So, I mean, what we're going to have to do is go back through all of the secondary legislation, primary legislation we have adopted to bring into force EU laws, and consider what of that we want to amend, what we want to retain wholly, and what we want to scrap altogether. Now, that's a massive undertaking, Michael. So, for example, between the inception of all of its predecessors and up until 2012, the EU had adopted over 100,000 legislative acts, and we're going to have to go back and trace through how they impact on our domestic legislation. And we need to figure out the policy that we want to adopt in relation to each of the sectors that they touch upon, and then legislate to give effect to that policy. Not all of that will fall within the competence of the Westminster government. Some of these issues will fall within the competence of the devolved legislation, the devolved legislatures. So, for example, in terms of environment, that is actually a devolved matter. And although traditionally what we have seen is the nations in the EU taking a similar approach by virtue of the fact they have to accord with EU law, if we then take that away, we could see divergence in areas such as that. Whenever you look at highly regulated sectors, it will depend on how the government of the day, whenever it gets round to looking at that particular sector, wants to proceed. And it also depends on the history of the sector. So, for example, in energy, we had energy regulation in the UK long before they thought of it in Europe, and they pretty much adopted the model that we had. So we're probably not going to see an awful lot of change in energy in regulatory terms. Something like telecoms, however, at the other end of the spectrum, there was a massive European impact. We used to have a licensing regime for telecoms in the UK, and it was only by virtue of European law in 2003 that we scrapped that. Now, given the fact that we are over a decade without a licensing regime, it might be that we don't actually go back to one. It all depends, as I say, on when the government gets around to looking at these various sectors and how it then wants to proceed based on where we are at the minute.
Sarah, you do a fair bit of sort of what I might call central government contracting. Do you see that element of the market being liberated by what's going on, or plunged into a state of confusion?
Well, it's interesting, isn't it? I've already spoken about the procurement regulations, where I think there won't be change anytime soon, because those are part and parcel of English law. But actually, if you look at the wider sort of public sector culture, I suppose, and requirements to make sure that you're obtaining value for money, accountability, etc. Again, I don't think those principles are going to change fundamentally. And it's interesting, if you look in the university sector, where actually they've recently decided that some of the universities are actually moving outside the scope of procurement rules. Actually, they're voluntarily deciding that they still want to follow the rules, because actually they do demonstrate that, if you like, they're appropriately spending the money that they've got. So I think it comes back to the accountability piece as much as anything, in terms of the broader policy context.
Andrew, you're involved in what I might call sort of board level corporate risk, stroke, health, safety, that kind of thing. Do you have any particular impact on your neck of the woods?
So I think in the UK we are generally considered to be world leaders in terms of managing risk, managing health and safety risk and risk to the environment. That's the result of, and that's good for business. It makes us more efficient. It's a good thing to be. So I don't think in the short term there will be any change to that at all. Most of that is the result of the UK legislation, which remains in force and remains in place and will continue to do so. It's also the result of the culture that we've built up over the last 50 years as a result of that legislation. In the future, I think longer term, there's an opportunity perhaps to make risk management legislation more tailored to the UK economy. It might become perhaps less prescriptive over the longer term and more responsive to what we need in the UK. But I don't think that it's in our interests to give up years.
Okay, thank you, Andrew. Peter, you've got a specific question up there, but probably which is around whether you should consider using other EU member states for the application of binding corporate rules in relation to data protection. Can you speak that up in your sort of general comment on what practical things should you be doing now with data protection?
Right. Okay. So. Perhaps I will focus on the data transfer issue, because that's cropped up in a few questions, I think. So, as I said earlier, the my best bet is we will end up with some version of the GDPR as part of UK legislation post-Brexit. If that assumption is correct, then I would hope that the UK will be treated as a white-listed country under the EU rules, an approved country for data protection purposes, and therefore we would not need additional things in place, such as an equivalent to the US Privacy Shield arrangements that are currently being negotiated. I think that's the sensible route for the UK to go down, to enable data transfers to continue to the UK and post-Brexit. I think there's a specific question around binding corporate rules. I don't think there's a clear answer to that as to whether or not, if you are currently considering binding corporate rules, whether or not shifting your jurisdiction. In fact, what you should be doing on binding corporate rules is going with the regulator where your main place of business is anyway, frankly. So if you are a UK headquartered business, I would still go with the ICO as the lead regulator on your binding corporate rules process. And I don't see a good reason to change that currently. Obviously, keep that under review over the next year or two in terms of whether we are going to have the GDPRs in place at all. Because if we don't, then binding corporate rules will not be something we will have post-Brexit. But as I say, if we have some version of the GDPR in place anyway, binding corporate rules will probably form part of that. And I would like to think that if we are an approved country, that we would still be seen, for those purposes at least, as a place where you could use our regulator as a lead regulator. So in a nutshell, I wouldn't be shifting from the UK currently.
Okay, we've got a very specific question about European passport rules, and which allow obviously financial institutions to passport into continental countries from London. Bernardine, I think you might have a view on that.
Yes, basically the European passport as it applies to banks, it's simply an expression of the fundamental principles of free movement of goods, people and services. So yes, EEA countries such as Iceland, Norway do benefit from that European passport. So the answer to that will depend upon what trading model we adopt with the EU. So for example, if we are to go for a bundle of bilateral agreements such as Switzerland, it will depend upon whether we conclude successfully a bilateral agreement on financial services. Switzerland doesn't have such an agreement, and so for that reason we have a number of Swiss banks who want to operate in the EU. They basically have located themselves within the EU. At the moment it's in London, so clearly whether they'll have to relocate to benefit from that passport. So I'm afraid the answer will very much depend upon what trading model we have with the EU in the future.
Okay. Question, actually, if I may, for actually before that, probably worthwhile commenting on the issue of intellectual property, which has come up, and obviously intellectual property tends to be quite an international product, and we've obviously got quite a lot of what might call European cooperation. The interesting view on that is that there might be one or two very pragmatic issues that might come up for debate around the relationship now between Europe and the UK. At the moment, the UK is in line for getting the life sciences court in London, and I do slightly worry what the appetite will be amongst other European states for the UK jurisdiction to be the centre for life sciences litigation, traditionally a very lucrative and part of the business and very important part of the business. The good news, I think, broadly in relation to intellectual property is a lot of it is by reference to, a lot of the international elements is by reference to international treaty, but not specifically EU international treaty. The one that's going to be most effective, I think, is what I might call the trademark framework, which is very much based on European legislation and obviously deals with community registrations as well. But much of the other stuff, patents, copyrights, is broader than that and governed by more international treaties that are less EU specific. But actually in the IP end of things, lots of things to get your head around, and it's only going to get more complicated for those involved in international businesses to secure IP protection. A question for David, if that's all right. my view in relation to Brexit was that suddenly I have to worry about tariffs and trade barriers and funny kind of customs permissions that I didn't used not to have to worry about before. Is that going to be the case?
Well, potentially, depending on exactly what deal we do with the EU. As Bernardine said, is it going to be a Turkish deal where it's a customs zone which allows preferential tariffs but doesn't stop? There are still borders and barriers that you have to go through. So, but of course, people in the UK and around the world trade happily with each other. We do international trade deals with Brazil or India where you have to worry and deal with those issues. It's just that to date in the EU we haven't really had to worry too much about that. We know that if we've got a French customer, we can send our stuff to France and it shouldn't be a problem and the contract will be straightforward. Now we'll start having to worry about trade barriers in terms of tariffs, but also other barriers, that customs can establish on borders, which may make it more difficult to trade. So I think to date we've been able to be lazy about trading with the EU. We haven't had to worry about those international trade issues that we've had to worry about the rest of the world, and we'll have to up our game for doing the EU trade. But we do, after all, do that with the rest of the world, so it shouldn't ultimately be the worst thing, subject to what those trade barriers are actually set out.
Okay, I've got a question coming in on the community trademark. What will happen to the community trademark? I'll probably share this issue, if I may, with Bernardine a bit. But my view in relation to this, of course, is that in relation to existing registrations, it's going to be very difficult. I don't know what the principle is about removing rights that you've already got as a result of leaving the EU. That's going to be a very tricky area. I'd imagine that some way of entitling existing registered community trademarks to survive, that will be put in place. What could well happen, though, for the future, unless we do some deal, is that we will no longer be able to benefit from the CTM going forward, the community trademark going forward, and that if we will be facing what used to be the old position of, if we wanted a pan-European protection, we'd be filing, and we're a UK business with a UK brand, we'd be filing 2 applications now, not one. One in relation to the UK. Who knows, at some future point, one in relation to Scotland, or even Northern Ireland, Kieran. I've picked up your brogue over the airwaves, and then a separate one in relation to the rest of the community. Yeah. And actually, whilst it would make sense for the scope of those rights also to be coterminous and exist together, they will not necessarily do so. There may all be some very subtle distinctions between those rights, which the leavers might say, well, that's one of the reasons for leaving, because you can have that flexibility to make the UK market potentially more competitive, or maybe less competitive.
We are issuing a note, by the way, on the implications for IP, because they are complex and difficult, and we're specifically also looking at what's going to happen to the community trademarks. Yes. Watch the spot on that. Okay.
Kieran, I hope you don't mind picking on you, but it's an interesting issue that certainly occurred to me last night, is Northern Ireland and Ireland. It's almost a sort of melting pot for all the issues that might arise. But what do you think?
Well, we will see some of the most interesting repercussions around the border between Ireland and Northern Ireland, because of course Northern Ireland is the only part of the UK that actually will share a land border with the EU when we do leave. Now, there had been an awful lot of what one side called scaremongering and what the other side called realism about whether or not that border would actually harden whenever we leave the EU. So traditionally, one can drive from Belfast to Dublin without noticing that you've crossed the border, save for a change in road signs and the colour of road markings, from miles to kilometres and from white to yellow. But the question is whether, because it will now be a border between the UK and the rest of the EU, that hardens in some way because of customs restrictions or because of potential impacts on immigration, for example. Some have said that a route through Southern Ireland could be used as a way of immigration coming into the UK. if we have sought to harden our immigration requirements for people coming in by plane, for example. But one of the other interesting aspects of the Northern Irish dimension in all this is the extent of which EU law has played a part traditionally in the various constitutional settlements that we have seen in Northern Ireland. So, for example, under the Belfast Agreement and through its update in the St Andrews Agreement, EU law has been very much written into the process. We have, for example, a North-South Ministerial Council under the Belfast Agreement, and whenever that is meeting and whenever it is taking a view on issues, it has to actually take into account EU law. So we have to think about whether or not that will go forward.
Sunil, if I can just take your view on that. I mean, again, on a much more sort of international stage, I just wonder whether you've got any views on the impact on Brexit on the UK as a gateway to, you know, what I might call pan-European transactions, and the fact that it's best to get the work done in the UK and then delivered, coordinated internationally, whether we'll miss out on that and from a corporate point of view.
I think that there is a risk that we may do so, because the UK is seen very much as a gateway to the EU for international investors. I think part of the challenge lies in how we renegotiate our arrangements with the EU member states, and to what extent we retain all of the, or many of the advantages that we now have by virtue of membership. I think the next 2 years in that sense will be quite interesting, because it may well be that people still see the attractiveness of London or the UK as an entry point and make the most of it. I think the more interesting debate will be around what happens after that. So you've made the investment through the UK. There are other attractive options to do it, whether it's through Holland or one of the other member states. But I suspect that it will be very high on the agenda of any renegotiation of the treaties and the arrangements to ensure that that attractiveness advantage remains.
And how worried are you about the loss of London's influence as a financial centre? And I heard the other day that apparently all euros are cleared in London, and the French are now making a really strong bid to get that process done in Paris. Do you see there's a sort of flight risk of financial services, businesses and expertise drifting towards Europe?
I think that certainly not in the short term. The longer term threat or the longer term risk is mainly around a point that was picked up earlier about passporting, and particularly passporting for financial institutions into the EU. And I think if those arrangements can be retained, then the threat to London as the financial centre for Europe diminishes. It's quite interesting that if we look at what's happened to the FTSE this morning, the stocks that have taken or borne most of the brunt of the reduction have been financial institutions, and particularly banks. Okay.
Bernardine, we've got the issue of state aid. State aid is two words that always goes together with European Union. Is there going to be an impact on state aid? Are we going to?
Yeah, not in the short term, but ultimately what the state aid rules do is it tends to keep the lid on people competing with each other in terms of the amount of aid they give to their respective industries. So we're out with now that club where there's that safe zone, frankly. So we may well be subject to clearly what sort of trade policy the UK will put in place to stop that sort of behaviour, be it through anti-subsidy rules, anti-dumping rules. I think the difficulty is there. Traditionally, the UK is very open, and it's far less protectionist than the rest of the EU. So from that respect, I think the EU would quite glad to see the back of the UK, because we actually do tend to put the dampeners on trade measures against, for example, China. So we may see them becoming more protectionist. And the other aspect I see changing as well, we probably as a country get more in state aid as a result of the EU rules, because the EU rules essentially insist often on, say, if funding's coming from the EU, on match funding. So we'll only get access to that EU funding where the UK matches the funding. So that will wither on the vine, and so we may well see a dislocation of reallocation of resources that otherwise would have gone, for example, to R&D, to joint ventures around the Internet of Things, etc., etc. So that whole R&D, seed-based capital landscape will shift and change, query whether it's going to be the same amount of funding from the UK government as we are currently seeing.
Okay, I mean, what I'm picking up is that in the short term, business as usual a bit while we all pause for breath and try and work out what's going to happen. But obviously, what's coming down the track is a real opportunity if you like to take the best view on what change provides. A real opportunity to renegotiate a relationship with either the EU as a collective or indeed, I guess, with individual countries as we choose to. Now we've got that freedom. I just wonder whether what the panel think, if I can sort of put it out to any of you to answer really, the extent to which UK business as a collective ought to be engaged with lobbying and shaping that policy, and put it in the reverse, the extent to which the phrase coming out at the moment, the political classes, who seem to have disenfranchised themselves from the electorate as one of the suggestions of the result is, or the extent to which the political classes will actually take account of what UK businesses want in shaping the future. Does any of the panel have any views on the best way in which UK businesses might engage with the process and perhaps shape it? David?
I mean, obviously there's an opportunity for businesses to identify areas whereby repealing legislation they can cut their costs. And I would have thought any business and every trade association will be reflecting upon when the issues Martin's raised about employment rights, or do we really need the commercial agency regulations? What can we do about product safety regulations? So there is opportunity to drive down costs. And of course, if we are changing our relationship with the world and our trade relationship with the world, that will also throw up huge international opportunities. So I don't think business should necessarily be too down in the mouth today, because there will be opportunities as much as there are threats to the diversity. The weakness of the pound this morning shows the instability and volatility of the markets, but for any exporter who's largely sourcing their materials in the UK, it's great news and propels them onto a world stage that they haven't been able to access. So they would be the opportunities. But I'm not going to take your invitation to comment on the bigger socioeconomic issues, Michael, but if one of the other panel members wants to take that on, that'd be happy.
Is anyone brave enough to do the? Oh, Kieran putting his hand forward there.
Well, I wasn't going to talk about the broader socioeconomic point. I was going to talk about the consultation point, actually. I mean, as well as sort of standard lobbying mechanisms, one of the interesting dynamics that we're going to see unfold over the next couple of months is the extent to which government lets anyone else into these negotiations. I think they're going to have to take the will of Parliament to some degree, and that's probably best done through input from the relevant select committees, so the Foreign Affairs Committee, the European Union committees. And those committees will, I think, be turning to business and will be taking evidence and putting out reports based on what businesses tell them. So I can see a situation in which various select committees request trade associations, business leaders to come before them to give their views on the negotiations and how they're shaping up, and for that then to be fed via select committee into the government negotiating position. Okay,
another question, if I may, to the whole panel is, because in this room we have various people focused on some of the various sector groups that we specialise in. Is anyone picking up any particular concerns around particular sectors that are going to be affected by Brexit? I mean, there was some comment this morning again in relation to automotive, and the impact of car imports and exports' ability to set up factories, which was just quite interesting. I just wonder, we've got representatives here who are active in technology, who are active in energy, who are active in automotive, food and drink, real estate. Richard, does anyone think any particular sectors particularly exposed to what's going on?
I think possibly in the long term we won't have the benefit of the UPC, the Patent Convention, the European Patent Convention. So that will be that's problematic.
Yep. Okay.
I think, Michael, there's a question that's coming about the possibility of some sort of tiered freedom of movement regime as between wealthier Western European and relatively poorer Eastern European countries. I think a sector that might be affected that would be the hospitality, hotels, catering sector, which is reliant to some degree on a significant amount of Eastern European labour coming in. It seems likely over time, if freedom of movement isn't available from those parts of Europe, that it will push up the wage costs of those sectors. Certainly in part of the campaign, there were some videos put out about, if you go out to buy lunch in central London and go into a sandwich shop, is there going to be anybody serving behind the counter? Or are you going to find that it's going to be stocked by English people? And given the importance of immigration, migration and freedom of movement in the whole political debate about this, that's going to be a pretty vexed and important issue, I'd have thought, going forward. Whether we'll end up with a tiered approach, I honestly, I have no idea how that might pan out. I can see there'll be a need for it to be retained to some degree, but how does that manage to balance itself with the perception that the majority vote was in favour of limiting free movement of labour?
Okay, there's a very technical question coming in here for Sunil. I don't know whether Sunil's smiling or laughing because it's such an easy one to answer, or one where his stomach's sunk to his boots. But we've got a particular question, which is probably our last question at the moment, if that's okay. I'm keen that we finish on time. But we have, obviously, European companies. Société Européenne requires two constituent parties. And the technical question is whether a UK company was still able to constitute one of those parties.
It is a very technical question, and I don't think I have a definitive answer on it. I would be surprised if there weren't some kind of grandfathering arrangement so that existing European companies can continue to operate with the constituent members, even though one of them has, as it would be the UK member, has subsequently left the EU. Because I think it would be too much of a disruption to business otherwise.
Yes, okay. Probably as a final question, I'm conscious, I never say final twice, I've just said final questions twice, but the last one that's come in is particularly interested, which is if we've been hobbled by EU rules in negotiating trade deals outside the EU, how are we going to be able to make deals with members within the EU now we're out, and vice versa? How will they make deals with us? Bernadine, I'll probably give you the last word, if that's okay.
No. In short, you can't, because the external trade policy falls within the exclusive purview of the European community. This is one of these areas where we have pooled sovereignty. So there isn't the possibility for separate trade deals with individual member states. You have to negotiate with the EU as a whole.
Okay, well, that's the what on earth's going to happen now we leave Brexit webinar from Gowling WLG. It just remains for me to thank the panel for their time, and also to thank the audience for listening in, whether you've asked questions or not. We've really appreciated the fact that you've spent time with us. So I hope you enjoy the rest of what's obviously going to be a very interesting day. Thank you very much.